Hello, my name is Elisabeth Steindl. I work for the University of Vienna at the Department of Innovation and Digitalisation in Law, and I'm also affiliated with the research platform Governance of Digital Practices. Now, perhaps let me share my screen with you. So now you can see our beautiful main building. The Department of Innovation and Digitalisation in Law is the most recent department at our law school in Vienna. The department deals with a very wide range of legal questions from a European perspective, with a focus on IT and IP law, and a special emphasis on privacy and data protection. We, apart from our academic teaching and research, we participate in a wide range, again, of third-party funded research projects on a national level, but especially also on an EU level with programs such as H2020 and Horizon Europe, for example. There we have two strong fields of experience. On the one hand side, the area of healthcare, digital healthcare, and law enforcement on the other side. Now, within the field of digital healthcare, we as a department, I as a researcher in particular, have taken an interest in digital mental health care, and I'm trying to establish a sort of a subchapter on digital mental health under the umbrella of our bigger field of experience on digital health. If you have any questions, please go and check our website. If further than that you have questions, ideas, suggestions, you are very welcome to contact me personally. You'll find my email address here. My contact details are also at the end of the presentation. Now, when I was asked by Becky to give a short presentation here at the conference on digital innovation in mental health, which is mainly attended by mental health experts, I thought me as a lawyer would kind of possibly contribute here. And then I thought one of the topics here is going to be cybersecurity. Perhaps it would be useful to have a very brief introduction on the legal and policy framework by the EU on this topic. The four legal pieces, initiatives, strategic initiatives that would immediately come to my mind would cover the GDPR, the General Data Protection Regulation, which most of you will be familiar with, the NIS Directive, the Network and Information Security Directive, the Cybersecurity Act, and also the new EU cybersecurity strategy. Perhaps it's also important to understand and to point out that these three legal pieces and that strategy try to target the topic of cybersecurity from very different angles. Whereas the GDPR is concerned with the protection of personal data. That's the main goal of the GDPR. Wherever there's personal data, you can go to the GDPR and see what does the GDPR provide for that case. So whereas GDPR is about personal data, the NIS directive, on the other hand side, is concerned with the protection or the security of the systems. It's not the personal data that is protected there, but it's the systems, the network and information systems. The Cybersecurity Act, instead, has, again, a very different target. It's not about the protection of personal data. It's not about the security of the systems, but it's concerned with the security of the products, the services, and the processes in order to make cyberspace secure. And lastly, the new EU cybersecurity strategy, next to many other things, is concerned with an even stronger emphasis on EU-wide collaboration. Now, I thought perhaps GDPR, I'm going to focus only on the GDPR, since I realized that talking about all of them would be far too long. And then I thought perhaps I'm going to bring the GDPR down to a case that many of you will be familiar with, our exemplary case. Could be, for example, the cyber attack against the Finnish company Vastaamo. We all heard about this attack in 2020. in the fall 2020. But in fact, the case goes back 2 years earlier. In 2018, the patient records were first accessed due to security laws, which continued to exist for a couple of months, but nothing happened at that moment. In 2020, the attackers demanded ransom money and threatened to publish patient records of approximately 40,000 patients. Only then, at the end of September, the company notified the Finnish authorities. A few weeks later, the patient records were indeed published on the dark web, and only then the company notified the affected, meaning the patients. In 2021, the data was republished on the dark web. Around that time, the company was put into liquidation and filed then for bankruptcy. The criminal case, however, is still open and the investigation is ongoing. Now, if we try to apply the law, the GDPR, on that case, first of all, first thing a lawyer would do is to see whether it's actually, whether we are actually in the scope, within the scope of the GDPR. GDPR only applies to personal data, so meaning data, personally identifiable data of related to natural persons. In the case of Vastaamo, we had the names and addresses and social security numbers of patients that were leaked. Now, that means clearly we do deal with personal data here. The term cybersecurity, which was our starting point, does not come up in the GDPR. The GDPR has a very different terminology, but you find something here which is called personal data breach. Personal data breach is a breach of security that leads to destruction, loss, alteration, or unauthorized disclosure of or access to personal data, which is exactly what happened in the case of Vastaamo. So we had their attackers that disclosed and first accessed and then disclosed personal data without authorization. So we do have a case of a personal data breach. Next thing a lawyer would do is, okay, what are the requirements? What does the GDPR provide? What does my law that I'm talking about here provide for a case of personal data breach? There mainly three things would come into my mind. On the one hand side, where the security requirements met, on the other, where the notification requirements met, and as a consequence, in case of non-compliance, what are possible sanctions that could be set. Now, as for the security requirements, probably I'd first go to Article 35 GDPR, which demands a sort of risk analysis, an assessment of the impact of the processing, which should be done prior to the processing by the controller, in case the processing is likely to result in a high risk. Right? The terminology here of the GDPR calls that impact assessment, data protection impact assessment, DPIA. And it makes clear, it points out in section 3, that such a DPIA shall in particular be required in the case of, and if we then go to letter B, processing of a large scale of special category of data. Okay, special category of data does include data concerning health. Data concerning health does, of course, the first criteria is met, we are in a special category of data. Other criteria, processing of large scale. Well, if we think of the 40,000 patients and data of these 40,000 patients that were affected, it's fair to assume that a DPIA would have had to be made. Now, secondly, security of processing, Article 32 GDPR, that provides that the controller and the processor shall implement the so-called appropriate technical and organizational measures, the TOMs, and lists as examples, for example, pseudonymization and encryption. What the GDPR wants is to ensure that the confidentiality and integrity of processing systems and services is guaranteed and maintained. And it also provides for regular testing and assessing and evaluating of the effectiveness of these TOMs, technical and organizational measures. In section 2, the GDPR makes clear of that article 32, of course, sets out that in assessing the appropriate level of security, which does, of course, take into account the state of the art, the cost of implementation, and so on. So in assessing the appropriate level, account shall be taken in particular of the risks, and then it refers straight back to the risks of a personal data breach, saying from risks from accidental or unlawful destruction, loss, alteration, unauthorized disclosure of or access. That is clearly referring back to the legal definition that we just covered, talking about the personal data breach. Thirdly, I'd also think about the principle of data protection by design and by default enshrined in Article 25 GDPR. Here it says the controller shall implement the appropriate TOMs, again, such as pseudonymization, which are designed to implement the principles of the GDPR, such as, amongst other things, data minimization, and to integrate the necessary safeguards. So, bottom line, and having heard all about or just the main points of the security requirements, in the case of Vastaamo, the company's security practices were found to be inadequate. According to the reports, the sensitive data was not encrypted, and the system root password was very weak, which means that it's very likely that we had a violation of the security requirements here in that case. Now, second point was notification requirements. As for the notification requirements, there are two entities that are distinguished by the GDPR and which have to be informed, notified. On the one hand side, the National Supervisory Authority in Article 33, and on the other hand side, the individuals affected, meaning the patients in our case, in Article 34 GDPR. The threshold for notification of these two different entities is slightly different, and the threshold for having to inform to notify the individuals affected is slightly higher. If you compare the wording of these two articles, it says you have to inform, notify the supervisory authority unless the breach is unlikely to result in a risk to the rights and freedoms of natural persons, whereas it reads, as for the notification of individuals affected, they have to be informed, notified if the breach is likely to result in high risk. Now, such a high risk has to be assumed if we're talking about the processing or the leak, in that case, of data concerning health, according to Article 29 Working Party. So, bottom line here again, in the case of Vastaamo, we most probably had a failure to report and to contact the authorities and the people affected, in particular after the first data breach in November 2018. They should have been informed, both of them, the authorities and the people affected, should have been notified in November 2018 already. And just to get the timeline straight, the GDPR was implemented in May already 2018, which means it was fully effective in November. And which just brings us to the conclusion that most likely there was a violation of the notification requirements. As a consequence, if the requirements are not met, what are the sanctions in case of non-compliance? GDPR sets out the sanctions in Article 83, and there in Section 4, it explains that fines up to 10 million euro or up to 2% of the total worldwide annual turnover can be set as fines, sanctions, which are actually quite severe. That is some money. Right. As promised in the beginning, in wrapping up, I want to briefly touch upon what's lying ahead. The cybersecurity strategy of the EU was adopted on the 20th of December 2020. There are plans to build an EU-wide cyber shield. There are also plans to establish joint cyber units, including rapid response teams. These plans actually go back to 2019. They had some delay mainly because national security is not in the EU's competence. But especially in the last few months, especially since the pandemic began, the EU has seen an increasing number of cyber attacks against critical health infrastructure, and among those also critical EU health infrastructure. So these initiatives have been emphasized again. And now the plans that these joint cyber units shall be established by June 2020, so within less than a year then from today, and fully operational, it shall be fully operational a year later. And there are plans for a platform, an EU-wide platform across borders to coordinate responses and to share resources. Now, this is in the making. These are the plans for the next upcoming month and years. Because the one thing that is for sure is that the topic cybersecurity, especially in critical infrastructure and among those critical health infrastructure, will not go away. They will stay with us over the next month and years to come. With that, again, I can only emphasize, if you do have questions or would like to contact me personally, do so, feel welcome, feel invited. I thank you very much for your attention, and perhaps we're going to meet next year in an on-site conference in London. Goodbye.